Assalamualaikum to Cik Nur Hamima and everyone. My name is Nur Adila Erna binti Zainal Abidin, meter number 01 DPM 30F1012, and my friends Nadira, Nazahan and Fakrul Amin. Today we are going to present about cases that related to company industrial issues, procedure, settlement and conclusion. Before that, let me briefly about arbitration. Arbitration is the process of solving an argument between people by helping them to an acceptable solution. Next, I will going to explain about the company. First company is Summerlin Resources Sendirian Berhad. Was incorporated in Malaysia with registration number 0139379 and registered on 8 May 1985. Type of entity is a private company and the entity performed is construction and infrastructure. Located at 94000 Bahu, Sarawak. While EcoWaste Berhad is Malaysia-based company and activity segment is operation, property, development and construction. EcoWaste is located at Wisma EcoWaste 33 Jalan Desa Gombak 6, Taman Desa Gombak, Kuala Lumpur. Type of entity is shareholder. Next. So, the case that we choose is Summerlin Resources decision. High Court states arbitration proceeding pending court issues grounded by Aliza Sulaiman 2021. So, that's all from me. Now, I'm going to pass the presentation to the next presenter. Thank you.
Assalamualaikum and hi. My name is Mak Fakrul Amin bin Azhari and my matric number is 01 DPM 20F1031. Now, I'm going to talk about industrial dispute. This case shows the court having to carry out a difficult balancing out when there's an overlap of issue to be determined in arbitration and the in-court proceeding. That's overlap and different parties could involve some parties to an arbitration and agreement and some entity who are not party to the arbitration agreement. Here, the plaintiff filed a court suit against the first defendant and second defendant for, among others, misrepresentation relating to the construction project. Related to this project, the plaintiff had also signed a joint venture agreement with second defendant. A dispute arose from the joint venture agreement and the second defendant had already initiated arbitration against the plaintiff. I think that's all for me. Now I will pass to next presenter.
Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Nadira binti Muhammad Nasruddin. My metric number is 01 DPM 20F1026. Now I will talk about procedure of arbitration. Based on the cases EcoWaste Berhad and its wholly owned EcoWaste Construction Sendirian Berhad are being sued by their former joint venture partner Summerlin Resources Sendirian Berhad over a dispute involving work on the Sarawak portion of the Pan-Borneo Highway project. The dispute was referred to an arbitration process. An arbitration is a process by which a dispute between two or more parties is resolved by an impartial third party, called an arbitrator. So, the arbitrator will become the master of the procedure subject to the rules of natural justice, and based on the cases, both parties decide to appoint an arbitrator to solve their dispute. Hence, with the agreement by EcoWaste Construction Sendirian Berhad and Summerlin Resources Sendirian Berhad, they agreed to appoint a professional engineer and chartered arbitrator as the arbitrator to solve their dispute. Then, the arbitrator will conduct a hearing to determine the relevant facts of the case from both sides. After hearing the relevant facts of the case from both sides, then the arbitrator will make a decision which the parties are bound to follow.
Ecovest and Ecovest Construction have sought necessary legal advice, and in the opinion that they have a good defense to the claim brought by Samli, as the latter failed to expeditiously and diligently make the necessary prior applications for the approvals from Lebuhraya Borneo Utara Sdn Bhd for the subcontract of the project to Samli Ecovest JV Sdn Bhd. Ecovest added that Samli also failed to take any steps to compel Lebuhraya Borneo Utara to consent to the subcontract of the works to the JV company, which should not have been unreasonably withheld. Ecovest and Ecovest Construction will also consider filing relevant striking out applications where necessary. In the end, the court granted the second defendant's request to stay the plaintiff's legal action against the second defendant. However, the court attached a requirement to the stay. The arbitration for the second defendant itself had to be stayed. The arbitration stay would give the plaintiff time to decide how to proceed with their claim against the first defendant. The ruling showed the broad restrictions that the court may apply when a stay is granted pursuant to Section 10 of the 8A 2005. In order to prevent any inconsistency in the resolution of overlapping concerns, the court was also prepared to order a stay of the arbitration procedures itself. Malaysia continued its growth as a centre for arbitration. The 2005 Act provides a coherent modern legislative framework in line with international norms and best practices. As it stands, Malaysia has all the components in place to take off as a centre for international arbitration. Recent decisions of the country's domestic courts underscore the fact that the Malaysian judiciary is now distinctly pro-arbitration. Given the current arbitral landscape and the progressive and innovative approach taken by the AISC in promoting Malaysia as a cost-efficient centre for dispute resolution, the country is poised to tap into the significant growth of international arbitration among Asian nations and in the Asia-Pacific region. The right foundations are in place and the future remains bright. That's all from us. Thank you.